Does who you list as a beneficiary of, say, your 401k or Roth IRA, does that supersede who you list in the will? Or does the will supersede the beneficiary designation? I've got that and more coming up. My name is Mike Bernard. I'm the host of the Wise Money Show. I'm also one of the certified financial planners right here at Korhorn Financial Group. Make sure you hit that subscribe button, turn on notifications, and smash that thumbs up button. Get this question all the time. I've listed so-and-so in my will, and with the expectation that, well, then all of their assets, all of this individual's assets will then go however you listed it in the will. But wait a second. Does the will supersede or overrule who you listed as beneficiary, or does the beneficiary designation supersede or overrule what the will states? Here's an example, guys, and I've seen this one before, where you start your first job right out of college, you're not married, there's no love interest, there's no prospects on the horizon, and ttherefore you list your parents as your beneficiary on your 401k because you've got to list someone, they tell you you need to, and you think, I guess I want everything to go to my parents, they've helped raise me. And then later you get married, and as you get married, you then have kids and all that, and you create a will, and you say everything goes to my spouse, and then from my spouse to my kids. But now you've got a 401k that says everything goes to your parents, and you've got a will that says everything goes to your spouse and kids. Well, which one's right? Which one supersedes the other? The beneficiary designation supersedes the will. And any financial planner that is doing comprehensive financial planning, they've read, they've heard, they've been taught these just awful stories of the one that stands out to me is a pension, $1 million pension, where an individual listed his spouse as the beneficiary of that pension, but then later got divorced and remarried. And when he passed away, the ex-spouse was still the beneficiary of this significant financial asset, and legally it had to go to the ex-spouse. And yes, there's some legal rules in there about, well, shouldn't that have gone to the spouse and so on, but situations like that, I've only seen one in practice, not at our firm, but heard about it and seen it through a different client. But yeah, that's so beneficiary designations supersede the will. So you can write out your will and say, I want my 401k to go to this person, I want my IRA to go to this person, I want my house to go to this person. But if there's a beneficiary form and for each of those assets, for any of those assets, that's going to supersede, that's going to overrule whatever you put in your will. Typically, we teach it like this as certified financial planners, as we sit down with our clients and explain the estate planning process. We usually teach that assets will pass in one of three ways, and usually in this order. One, they'll pass by law, and so that's based on ownership. Well, under certain types of ownerships, there's a law that says, well, it doesn't pass along to your kids, it just goes to the joint owner, or if you were married, then legally, it doesn't matter what you state, but legally the money or the asset has to transfer this way. And so that doesn't apply all the time, but that typically supersedes whatever your instructions are. So by law, assets could pass. And then if it doesn't pass by law, then second, it's going to pass by contract. And what's a contract? Well, a contract is a beneficiary form where you've signed off that says, if something happens to me, this money goes to this person or these groups of people. And so typically your retirement accounts, 401k, IRA, Roth IRA, there's part of opening that account, there's a beneficiary designation. And that's a contract. It's something that you state, this is who I want the money to go to if something happens to me, and you sign it. Life insurance is the same way. There's a contract where you say, if I pass away, this life insurance policy I want paid out to this individual, or I want it spread out to these individuals. And when things change, it doesn't mean you update your will. We haven't even gotten there yet. You update your beneficiary. There's a beneficiary change form where you log in and make that adjustment. So your assets will pass by law, very, very rarely, then by contract. And then if there isn't a contract, then it will pass by testate or intestate laws, which is by process of a will. And if you don't have a will, then it's intestacy, and basically it goes through the courts, and the court has their own way of dispersing or determining who gets your dollars, and it's very lengthy. and can be very costly, and it might not line up with your intentions. Therefore, you should have a will to ensure that dollars will pass as you intend them to. So a couple things to point out. A beneficiary designation is typically just for one account. So you can't say, well, oh, I'm rolling over this 401k to an IRA. I don't need to fill out the beneficiary form there because I already filled out the beneficiary form on my 401k. No, it applies to one account at a time. Therefore, your IRA is going to have a beneficiary form. And if you open up another IRA and another IRA and another IRA, they're each going to have their own beneficiary form, their own beneficiary designation. Same with your Roth IRA, same with your 401k. If you open up just an individual account, a non-IRA or a joint account, you're going to want to list a TOD, transfer on death. What does that mean? It turns it into a contract. That's where you add a beneficiary to it. Each account will have its own beneficiary designation. So which one's more important? Well, they're both important. They're both important. You want as much of your dollars passing via a beneficiary designation, via a contract, as opposed to a will, because those dollars avoid probate. And most people want to avoid probate. They think of it as a tax. They think of it as this penalty. No, it's a probationary period through which, through a public record, your dollars are then said it was your intention that these dollars are to go to these individuals. Does anyone contest that? And sort of goes through the court system of transferring that ownership. There's a process towards for that. So it is expensive. It's not a tax. It's just paying for the attorney's time and the court system's time to make that transfer and go through that process. Most people want that transfer to be as pain-free and cost-free as possible, as efficient as possible, and at the lowest possible expense. And therefore, listing a beneficiary is what does that. A beneficiary says, okay, I need a death certificate and we'll need some signatures, but then we can transfer the account immediately, and there's usually no cost for doing that. So this is why going through and getting an estate plan done, the sixth area of your overall financial life, the sixth, it's more than just getting a will in place. It's reviewing all of your assets. What are your intentions with each of them? Do you have the ownership right? Okay, that's that first tier that I mentioned. That's number one. Number two, do you have all the beneficiaries updated? And then doing an ongoing beneficiary audit to ensure that your intentions haven't changed, that you don't have that ex-spouse or you don't still have your parents listed, that it's all correct on there. So updating and getting beneficiaries on all the right accounts. And then third, that you have a will in place and sometimes a revocable living trust as well to kind of turn those dollars back into a contract, make it easier and avoid probate. But do you have a will and the other legal documents in place so that your intentions are carried out for any assets that don't pass by ownership or by law or by contract? Your estate plan is more than just getting a will in place. No, it's looking at your entire financial life and your intentions and ensuring it's all working together in the most efficient way and in the most cost-effective way possible to carry out your intentions with your dollars. Work with your CFP. When's the last time that you've updated or done a beneficiary audit? When's the last time you reviewed your will and overall estate plan? Work with your certified financial planner on that. If you don't have a CFP on your team, contact one on my team. Find us online, Korhorn.com. That's Korhorn with K, wisemoneyshow.com. You can find us there as well, or give us a call, 574-247-5898. All right, there you have it. Go out and take your next wise step in your financial life.